versus Justin Potter, file number 24-00639, counsel appearance.
Prosecutor Paige Petrosky on behalf of the people.
Jacob Rowley on behalf of Mr. Potter.
Okay, today was the date set for final pre-trial on a domestic violence and the people are unable to proceed, is that correct?
That's correct, Your Honor. The necessary witnesses failed to appear.
Okay, so you're moving to dismiss, but you're objecting to destruction of the arrest records under MCL 7-6426, correct?
That's correct.
Motion will be granted. The case will be dismissed without prejudice. They do have the right to reissue the charge against you within the statutory time frame, okay? Do you have any questions for the court? Additional matters for the record.
Nothing from the people.
Nothing from the defense, Your Honor.
Thank you. You're all set. We'll get you a copy of the dismissal. On the record in the matter of the people. State of Michigan versus Jerry Anthony Keene. He's in custody.
Yes, he is.
File number 24-03585, counsel appearance.
Assistant Prosecutor Paige Petrosky on behalf of the people.
Assistant Public Defender John Lee on behalf of Jerry Keene.
It was the date set for final pre-trial. There is a domestic violence, and then we have a PA 53. He is in custody. Is your witness here?
She, and I'm not sure why, because her subpoena said to appear in person, but she appeared via Zoom this morning. So we were unsure of how you wanted to handle that.
Deborah Rulson, can you start your video, please? Maybe she got disconnected. We'll see if she logs back in. Off the record on that matter. On the record in the matter of the people of the state of Michigan versus Brandon McKinney, file number 24-00290, counsel appearance.
Assistant Prosecutor Paige Petrosky on behalf of the people.
Assistant Public Defender John Lee on behalf of Brandon McKinney. Sorry.
McKinney? Yes. Have the McKinney file?
Oh, yeah, right here, Judge.
Thank you. Okay, Mr. McKinney, how are you?
Okay.
It was the date and the time that was set for a plea. Well, set for final pre-trial. My understanding is that there is a plea. Do I have an advice of rights? Okay, the people are offering for you to plead guilty to an added count 1 of domestic violence with no objection to sentencing under 769.4A. There's a killable agreement of no upfront share. Is that what you understand your offer to be, sir? And you want to accept that offer? Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury?
Yes, sir.
Thank you. You can put your hand down. Yes, please. Okay, you have certain rights, sir, that you would have to give up if you want to accept the offer. I do have an advice of rights and plea information sheet. The second page bears a signature. Is that your signature?
Yes.
Would you read this document?
I have.
You read all the rights here?
Yes, ma'am.
You understand those rights?
I do.
Do you have any questions about those rights?
No, Your Honor.
Are you willing to give up all of those rights today to plead guilty to the amended count 1 of domestic violence?
I am.
You understand that you have the right to the presumption of innocence, so you're innocent until proven guilty, and you have the right to require the prosecution prove your guilt at trial by proving each element of the charge being brought against you beyond a reasonable doubt. Do you understand that?
Yes, Your Honor.
You have the right to see, hear, or question in court any of the witnesses that the prosecution calls to testify against you. You have the right to remain silent, not have silence be used against you, but you can waive your right to silence and testify on your own behalf at your trial. You have the right to subpoena witnesses to testify for you at trial or present evidence that you believe show a defense to the charge being brought against you. You understand each of those rights and you're willing to give all of those rights up as well?
I am not.
Is anybody threatening you to get you to give those rights up?
No.
Has there been any promises made to you in exchange for you entering a guilty plea today?
I apologize.
Has there been any promises made to you in exchange for you entering a guilty plea?
No, Your Honor.
Are you currently on probation or on parole?
No, Your Honor.
I understand that a guilty plea could result in a conviction that you may need to report to your current employer, or you may need to place this conviction on a future job application.
Yes, Your Honor.
This conviction can also have impact on travel or immigration status that you may seek in the future. So you may not be able to travel to certain areas or countries with a conviction of this type. You understand?
Yes, Your Honor.
There's a killable of no upfront jail. That's an agreement between you and the prosecutor. The court is not a party to that agreement. Was that explained to you?
Yes, Your Honor.
Okay, so if I'm going to deviate from that agreement, I will let you know at the time of your sentencing, and I'll give you an opportunity to withdraw your plea. As to the amended charge of count 1 domestic violence, how do you plead?
No contest, Your Honor.
He's pleading no contest, Your Honor. I'm sorry if that was lost in the translation here.
This is Lawson, it says plead guilty
Oh.
to amended count 1.
There it
That's, my
And-
apologies.
And it also would come with the police report that was highlighted with the relevant section.
I can print one of those off.
I can't do a factual basis without a police report. We'll go off the record. Mr. Melks, who are you here for?
For Deshaun Johnson, Your Honor.
He's in custody.
He is. I don't know what we're doing on it though.
So you don't know what?
I don't know what we're, sorry, I don't know what we're doing on it.
Okay, he's downstairs. Okay, we'll have Deshaun brought up.
Thank you, Your Honor.
No problem. I don't see Miss Wilson in my breakout room, waiting room or virtual courtroom.
Understood.
She was there. When I asked her to start a video, she left.
Okay,
And so I'm gonna take that as her failure to appear because she was not supposed to appear via Zoom. Sir, how can I help you?
Yes,
I'm sorry?
we can talk in 1 minute, okay?
You want to talk to your attorney? What's your name?
Oh, this is not my attorney, this is my friend's attorney.
Okay, what's your name?
True.
Who's your brother? Oh, okay.
I'm sorry, I was just trying to figure out what was going on, find out what's the contact. I've never had to set up jail stuff, so I really need help trying to figure out how to do contact.
Okay, yep, Mr. Milks can help you at the appropriate time. Okay, and Mr. Abbott, you were here with,
Reynolds, Your Honor.
on the record in the matter of the people of the state of Michigan versus Jamar Green McReynolds, number is 24-00202, council appearance.
Assistant Prosecutor Paige Petrowski on behalf of the people.
Where you are, John Abbott, on behalf of Mr. McReynolds, he's standing to my right.
Okay, Mr. McReynolds, today was the date set for a jury trial. And I believe my understanding is that we were not going to trial today.
That's correct, Your Honor. We were informed yesterday that the lead investigating officer, Officer Selden, is out of the state on military orders. The people are unable to proceed with that as testimony.
Your Honor, I'd object to any adjournment. Understood that I did receive notice that she's going to ask for an adjournment today, Your Honor, but there were 4 police officers involved. Any 1 or 2 of them would have been enough to put the facts on the record. We're ready to proceed, Your Honor.
You said Officer Selden was,
Yes.
Officer Backery is still employed at LPD, and he was a witness, and there was an officer from Lansing Community College who was actually in the hallway this morning.
right, but it says count 2 police officer assault on Officer Selden.
Right, well, they were all there at the same time, all the officers. And there's plenty of body cam video.
And what, other than count two, is officers, was he necessary for count one?
So I believe on this file, because there's an amended complaint, there's only one count of attempted resisting and obstructing arrest. And that count was against Officer Selden.
Count two to attempted RNO, dismiss count one, okay. So we're just moving forward on count two to amended. And you did have other officers, the issue was,
Yeah, the issue was that Officer Selden is not present, was not able to testify.
but Officer Backery and the other officers were present?
Yes, they were here. Well, they were notified yesterday when we realized that we were that we did not have the primary officer that the resisting and obstructing occurred against. So Officer Selleck was here, but Officer Backery was on call, as well as and I apologize. The other officer as well, Hayward. Yeah.
Why wasn't it, I don't understand why you weren't prepared if you had other officers?
I guess, and I apologize if I was mistaken, but given that he was the complaining witness, I didn't think that we would be able to proceed without the victim in the case without any sort of, I guess, prior notification or handling things differently. I was under the impression that the complaining witness needed to be present for trial, or the complaining victim.
I think that part of my concern and frustration is that we have to set things out at least 60 days. But the prosecutor's office is waiting. It's a similar issue with the city attorney's office. To a couple of days before trial to confirm their witness. It's not due diligence. I am almost certain that the lead officer didn't just find out last week that he or she had to report for military duty. And had they been notified at a reasonable time frame before, they could have informed you, I have orders during that time frame that I can't be in court for trial. Then you could have put Mr. Abbott on reasonable notice. Mr. Abbott could have told his client in reasonable time frame. The court could have set it in a reasonable time frame. But if I continuously get situations where the prosecutors in the matter are not doing what they're supposed to do in a timely fashion, tying up the court stock, and you're tying up other people's stock. And that's not fair. That's not how we execute justice.
I understand.
I'm going to grant the request because it's something that I'm confident they're going to reissue against your client if I dismiss it for their witnesses failure to appear. And so I'm going to reset it this one time, but I'm going to admonish the prosecutor's office that they need to do better with contacting their witnesses. If I give you a final pretrial date and a jury trial date today for July, my expectation is that you are confirming with your witnesses, your necessary witnesses immediately that those dates work, not the Friday before the trial.
Understood.
July 30th at 8. July 30th at 8 a.m. Get you a copy of your notice to appear. Any additional matters for today's record?
I think some people.
No, thank you, Your Honor.
Thank you. Mr. Johnson. Can you speak on?
No,
Oh, on the record in the matter of the people of the state of Michigan versus Deshaun Alex Johnson and file number 24-00707 and 24-00708. Council appearance.
Assistant Prosecutor Paige Petrosky on behalf of the people.
morning, Your Honor. Steve Mills on behalf of Mr. Johnson. Mr. Johnson is present and staying at their right at this time.
How are you, Mr. Johnson?
Going a little better.
Very good. Today was the date and the time that was scheduled. We have a pretrial for an assault battery and a contempt hearing for assault and battery. And let's see. How are we proceeding?
On the contempt hearing, no witnesses were subpoenaed. And as far as the pre-trial for his misdemeanor matter, the people's offer is for Mr. Johnson to plead to count 1 and we will dismiss count 2.
Mr. Jones, how do you want to proceed?
Thank you, Your Honor. Your Honor, as today's the date and time for the bond violation or the contempt hearing, Your Honor, I would ask for dismissal. People are not prepared to go at this time. Understand that people have not called their witnesses here today. This is happening time and time again, whether it be preliminary examinations or even the hearing right before mine. At this point, I don't see any remedy in just adjourning this at this time.
It's a pre-trial.
I'm sorry, regarding the bond violation. I'm only here for the bond violation. I didn't realize he had a.
And Mr. Lee's representation.
Oh,
I call both files. Mr. Lee, you should put your appearance on the record.
Assistant Public Defender John Lee appearing on behalf of Deshaun Johnson.
Okay, let's see what the allegation of the bond violation is. The allegation that he cut off his tether. Bond violation, unlike the issue I just addressed with the prosecution office, is a contempt of court order, so I'm not dismissing it.
for good, Your Honor. Then I'm ready to go today.
We don't have a witness, so we're gonna reset it.
I may be heard on bond then, Your Honor.
The allegation is that he cut his tether off. Go free, knock yourself out.
Thank you, Your Honor. My client currently is sitting here with no bond at this time, Your Honor. He's been in jail for over 14 days at this time on this allegation. The people have once again not brought people here for this hearing, which just again benefits them to this point because my client has to sit in jail that much longer. Once again, it's to the complete benefit of the people to just not do anything here because my client's going to be in jail and they're going to get the adjournment at this point. Your Honor, I'm asking still that he at least be released on bond at this time, obviously with the tether requirement here.
Okay, thank you. Did you want to respond?
Just that I offer my apologies to the court.
Okay. Well, the concern that I have here is that I have in one file number ending 708, felony file, an assault with intent to do great bodily harm less than murder or by strangulation, an assault with assault and battery, felonious assault, a domestic violence, count 4, assault or assault and battery. And then I have file number ending in 707, assault and battery, and another count of assault and battery, all with different victims alleged to have been assaulted. In one file, I have defendant failure to appear, and so I had to issue a bench warrant. And his response was, well, I just got dates mixed up. That's after he had already had this felony pending, to which the court placed him on a bond, PR bond at that, personal recognizance, and with GPS tether. Now the allegations are that the tether was cut off and that appeared to be near the inclusion zone. And I recognize that we've not had a hearing, but your client was picked up in custody and there was no tether on. So the presumption the court has is that a release on tether is not appropriate because it would not secure the public, nor would it require him or compel him, that is, to stay in comport with compliance of the court order while he's out on bond. And we have 1, 2, 3, 4, 5, 6 separate counts of violent actions against members of this community. Bond is denied. He'll be remanded until the time that we can have a hearing on the bond violation.
Good with you for that hearing, Your Honor.
Set for an exam, the 23rd. And on the felony file, he already has an exam date of the 23rd. Right. Oh, I do see that. Yep, he has an exam date on the 23rd, which is when the victims on the other matter should be here. We'll have JSG subpoenaed for that purpose. And the prosecutor will take care. As to the misdemeanor file.
I'm sorry, Your Honor. We continue to remain hopeful that the misdemeanor file will be resolved as a result of a global solution on the felony file, Your Honor. So we would ask for an adjournment until such time as court thinks will be appropriate.
That will be reset to the May 23rd date as well, just as way of a status. Do you have any questions today, sir? Do you have any questions for the court?
I don't have no question, I just have, based on what I was texting,
Not a good idea? I didn't think so. Okay, any additional matters for the record?
Nothing from the people.
No, Your Honor, thank you.
Okay, you're all set.
Yes, I got you more.
Okay, let's see, what's going on with Miss Keene? Or Mr. Keene, we can bring up Mr. Keene. Who's representing Keene?
Oh, that's Mr. Lee.
Okay, we'll bring him. The record in the matter, the people of the state of Michigan versus Kamar Razai. File number is 23-01773. Council appearance.
Prosecutor Sage Petrosky on behalf of the people.
Assistant Public Defender John Lee on behalf of Kumar Razai.
Okay, today was the date and the time set for final pretrial. My understanding is that the necessary witnesses have failed to appear. The people are moving to dismiss without prejudice, correct?
That's correct, Your Honor.
There is an objection to destruction of the arrest records under MCL 764.26A.
Correct.
Could you explain to your client what that means?
Your Honor, my client, I was hoping that we would have an interpreter here. Her husband speaks a little bit better English than her, so I will explain to him what that means.
Husband's present. Who was the husband?
He's in the hall with their minor child.
Interpreter didn't appear?
Let's see.
Well,
I don't know.
circuit
When was
court. So what, you don't know, no. I don't know much. This person. Does she have any questions?
She had.
We'll get her a copy of the dismissal. Thank you. Okay, on the record, in the matter of the people of the state of Michigan versus Jose Tellez, file number 24-00714.
Assistant Prosecutor Pete Petrowski on behalf of the people.
And Jacob Riley on behalf of Mr. Tellez. Mr. Tellez is not present. However, they are spoke to him on the phone about 1 hour ago. He informed me that he has been hospitalized overnight. So I believe that is obviously the reason for his not being present today.
How do you want to proceed?
The necessary witness was notified of this date, and was properly subpoenaed, the people be moving to dismiss.
Okay, motion to dismiss will be granted. You can explain to your client what that means.
Yes, sir. Good.
On the record, in the matter of the people of the state of Michigan versus James Tortora.
Good morning, Your Honor.
Good morning, file number is 24-00475. Here, it's for the record.
Assistant Prosecutor Paige Petrowski on behalf of the people.
Assistant Public Defender John Lee on behalf of James Couture.
James Phillips, before Junior.
Oh, you're junior, is that correct?
Yes, ma'am.
Okay, did you get your fingerprints taken care of?
I had not. I went in there, they seemed not to know what I was talking about. I had somebody drive me over, so I didn't have forever there. No, ma'am. But I could do it this morning and do it.
I checked last year, so you were supposed to get him done on April 9th. It's a month ago.
The one time that I
Do I
went
need
in,
to remand you to get it done?
no, like I said, I could do it today, right now. I have time.
Okay, well, you're gonna do it, or you're gonna get a bench warrant, because I noted here, defendant to come today to be printed. That was a month ago. The people were moving to dismiss, and they want to object to your arrest records, but you haven't completed your arrest record. You go complete it, otherwise your case is not being dismissed.
Okay, you want to do it right now?
I wanted you to do it 30 days ago.
Yes, Your Honor.
Thank you. On the record, in the matter of the people of the state of Michigan versus Jasmine Collins, file number 24-01314, council appearance.
Assistant Prosecutor Paige Petrowski on behalf of the people.
And Jacob Riley on behalf of Jasmine Collins.
What's this young man waiting for? Submission. It's waiting for some public police report. Did they send it to you? I think they were gonna print it. Did they email it? Or Mr. Fairley might have it. Do you have the police report? Highlighted? Oh, okay. Okay, I'll do that one next. You can highlight the relevant portion. You need a highlighter.
I've got it done.
Okay, thank you. Okay, on Jasmine Collins, can you start your video, please? Jasmine Collins? She's not responsive. I'll move on. Okay, back on the record in the matter of the people of the state of Michigan versus Brandon McKinney. Yes, please. Thank you. Okay, and so, Mr. McKinney, the offers for you to plead no contest, I've gone over your rights. Those rights still apply to you, and as it relates to how you want to plead, is it guilty, not guilty, or no contest?
No contest.
What is the reason for the no contest plea? No, not you, counsel.
Your Honor, Mr. McKinney was drinking that day, and as a result of intoxication and the passage of time, his recollection of the events of that day are de minimis. However, he does not contest the allegations.
The people are not objecting to that, correct?
Correct, there's no objection.
Okay, I have police report, Green Lansing Police Department, case number 23519125253, dated December 10th, 2023. Officers reported to the area of 4245 West Jolly, lot 165, City of Lansing, County of Eaton. Objection is to that being within a 1 mile radius of Ingham County.
No, Your Honor.
No objection.
Okay, may convene in this court appropriate allegations are that the officer spoke with the alleged victim, Janima, who stated that Brandon advised that Brandon drinks, he gets very aggressive. The two were arguing back and forth. At one point, Brandon began counting down, threatening to do some physical harm to Janima. After counting down, he continued yelling, approached Janima, grabbed both of her shoulders and shook her. He then started slapping her head and pushing her around. It says Janima and Brandon are mother and son. Any additional factual basis?
Just that Janima and Brandon also reside at the same residence at that venue.
Let's say they both reside at the venue. Any additional factual basis?
Nothing further is on.
Okay, the court is satisfied with the factual basis. I find the reason for the no contest plea appropriate. I will accept your no contest plea. I find it to be freely, voluntarily, and intelligently. This matter is set for sentencing July 9th. When you leave here, you need to go downstairs to our probation department so you can check in. They'll get you set up for a pre-sentence report, an interview, so that we can get you a recommendation as to how you should be sentenced and find out whether or not you're eligible for sentencing under 769.4A, okay?
Yes, ma'am.
You may appear for sentencing via Zoom. Do you have any questions today?
No, Your Honor.
Any additional matters for the record, counsel?
Nothing from the people.
Nothing for the defense, Your Honor.
Thank you, you're all set.
So you just have a seat, we'll bring it.
Jasmine Collins, can you hear me? Letitia Jackson, can you hear me?
This is for probation.
Yes, I can hear you. Okay, on the record in the matter of the people of the state of Michigan versus Letitia Jackson, file number is 24-00576. Council appearance.
Assistant Prosecutor Pete Petrosky on behalf of people. Ms. Jackson is unrepresented.
Today was the date and the time that was set for pretrial on a dog license vaccination. How are we proceeding, counsel?
Ms. Jackson has provided people with information that she no longer is in possession of the dog. She actually sold it to another individual. And so for that reason, the people will be dismissed for compliance.
People's motion to dismiss is granted. You're all set, Ms. Jackson.
Thank you guys so much.
You're welcome. Heather Rose, start your video. Okay. On the record of the matter of the people of the state of Michigan versus Jasmine Kowak, and file number 24-00010, council appearance.
Assistant Prosecutor Pete Petrosky on behalf of the people.
Assistant Public Defender John Lee on behalf of Jasmine Kowal.
Okay, Ms. Kowak, can you hear us?
Yes,
Okay, today was the date and the time that was scheduled for a free trial for an assault and battery. Council, how are we proceeding?
Your Honor, at this time, the defense would request a final pretrial and trial.
Trial July 2nd. Trial July 2nd. Could it be trial again? 30? Okay. Final pretrial, July 2nd, in person at the court, 8 o'clock in the morning. Jury trial, July 30th, in person at the court, 8 o'clock in the morning. Was there an offer on this at all?
Yes, if Ms. Kowalk were to plead guilty to domestic violence, people would have no objection to 7694A if she's found eligible.
So the offer is to plead guilty to domestic violence, no objection to 769.4A. That offer will expire on July 2nd. Do you have any questions today, Ms. Kowalk?
Yeah. I just haven't spoken to my attorney at all, so I'm a little confused with stuff that's happening.
You never spoke to your attorney?
No.
I'd be confused too.
I represented Ms. Kowalk on a matter yesterday, Your Honor. We have had conversations. However, in regard to this matter, the conversation has been limited.
Ms. Kowalk, did you speak to your attorney yesterday?
Okay, my phone's so small, I can't really see who it was, but I had another case yesterday, so I spoke to him about that case, but with this case, I just haven't had a conversation.
Okay, and so you were not aware of the offer?
No.
Is that true?
That is true. She was not aware of the 769.4A.
Okay, well, how do you move forward with how she wants to proceed if you haven't even advised her?
Well, the offer is still open, and I would advise her on almost any assault and battery case to make the witnesses appear before you plead guilty as charged.
Yeah, I understand what your advice is, but you haven't done that. You haven't even given her an opportunity to know what the offer was. And so she could not, you could end up in a situation where you can't get in contact with her again until July 2nd. And so she finds out the offer on July 2nd.
Make sure that her and I have a conversation today.
Defense counsel should always speak to their client before court, just so that there's trust that you're advocating for them the way that you should. You don't want her to feel like you're not working for her because she's not spoken to you.
Absolutely.
Okay, Ms. Kowalk, your attorney will be in contact with you, okay?
Okay. Okay, thank you.
Yeah, we'll see you in person July 2nd.
Okay. All right, thank you. Is it okay if I leave?
Yes, you're free to go.
Thank you.
Let's see, Mr. Tutori, you all set?
Ma'am, Your Honor, well, I don't know, they acted like they couldn't do anything when I gave the ID. I need an order from you, like a piece of paper, give them what they said.
You have to get it from the clerk. There's an order.
Okay.
He needs to get his fingerprints done.
I'll be right back.
On the record in the matter of the people of the state of Michigan versus Heather Marie Rose, file number 24-00931, council appearance.
Assistant Prosecutor Paige Petrosky on behalf of the people.
Assistant Public Defender John Lee on behalf of Heather Rose. Your Honor, I'd request a moment to review the actual restitution amount in this Rose to make sure she's prepared to go forward.
Okay, we're off the record. Is somebody else waiting for?
No, that was our interns from our office, undergraduates at Michigan State University.
Someone named Big Surge. It's iPhone. Big Surge, start your video, please.
Oh,
I can see you. What's your name?
sorry.
What's your name,
How you
sir?
doing, Your Honor? Sergio Archer.
Okay, do you have an attorney?
Yeah, John Lee.
Huh?
Yeah, sorry.
And then we just did a benchmark for this person yesterday. Yeah.
Since Mr. Keen and Mr. Archer are both Mr. Lee's clients, is it okay if I go and dismiss the victim on Brandon McKinney?
Yes.
Thank you.
Who's representing Mr. King? Who represents Mr. King?
Oh, Mr. Lee.
Yeah, he needs to go talk to Heather Rose, but we have an inmate waiting for him.
Oh, no. What is that?
Okay. On the record in the matter of the people of the state of Michigan versus Jerry Anthony King, file number 23-03585, council appearance.
Assistant Prosecutor Paige Petrosky on behalf of the people.
Assistant Public Defender John Lee on behalf of Jerry King.
Date and time that was set, Mr. King, for a final pretrial, that is, and a PA 53 violation. Let me see here. Victim appeared, but then she didn't appear properly. And then she left. So what are we doing? Mr. Lee?
I would make a motion to dismiss your honor.
Yeah, motion to dismiss. She appeared, she just didn't appear properly. I didn't get a chance to understand how she even thought she could appear via Zoom or why she appeared via Zoom. Well, I know she was sick and didn't want to infect the courtroom. I don't know.
Then I would ask that we reset the final pretrial date because we don't know what she appeared to say. Maybe she was appearing to say, hey, would you guys please drop the charges?
She should have appeared for that purpose and she was here. That doesn't mean that the prosecutor can't get in contact with her before that and find that out. If she doesn't want to move forward with the charges, then she can communicate that to the prosecution. The other issue is this was a allegation of a violation that took place, at least one of them, in the court with officer witnesses.
He accepts responsibility and pleads guilty to that violation.
Is that correct, sir? You want to, well, you have 3 violations here. He's pleading to the last violation.
As far as the violation for, or the violation for the calls made by Mr. Keen, well, obviously, ultimately, the decision is in the court's discretion. The people will be asking that the court not pursue the violation of the no contact order for the jail calls.
Why is that?
The primary reason is that Mr. Keen has been very helpful and forthcoming with information about trying to locate a missing woman. And based off of his cooperation with law enforcement, we were able to locate that woman and determine that she's safe and alive. And so it was just the request of the officer who had been working with Mr. Keene that that we asked the court not to pursue on that specific contempt charge. And I informed her that detective that ultimately, obviously, it's not my decision, it's a decision of the court, but that I could request that on Mr. Keene's behalf.
Yeah, I'm not in a business of allowing someone to violate bond conditions and potentially conflict with a witness from appearing because they cooperated or corroborated another investigation. If the prosecution wants to amend or offer special conditions for the charge that they're issuing because of that, that's up to the prosecutor. But a contempt of court order is not up for negotiation.
I understand. And just to be perfectly clear, the detective is fully aware of that. I just told her that I would make the request, but under the understanding that I have no actual say in whether or not that occurs.
Is that detective here today?
Yes, she is.
And how would we pursue, how's your client planning to move forward with that violation? Because I'm not dismissing it because of a cooperation with another matter.
Your Honor, Mr. Keene would like to plead guilty to the bond violations.
That's correct, Mr. King.
Yes, ma'am, Your Honor.
Raise your right hand. You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury.
I do, Your Honor.
Okay, are you suffering from some injury or condition?
No, I'm not.
Okay, then you need to stand up. Okay, so I have one violation here. It was a complaint of violation of conditional release, that you violate your bond conditions for no direct or having indirect third-party contact with the Deborah Rulison between the timeframes of March 3rd, 2024 and March 18th, 2024. There's a police report that indicates multiple jail calls. Total of 32 jail calls in violation of the court's order. And you want to plead guilty to those violations?
I do, Your Honor.
Okay. There's also a violation of conditional release, alleging that on March 2nd, that you failed to comply with the terms of your conditions, meaning do not use illegal controlled substances, do not have or cause third-party contact directly or indirectly with Deborah Rulison. As to that violation or those violations, how is your client pleading, Mr. Lee? And then there was, I think, a previous violation we might have addressed. Let's see. Okay, and a violation for March 28th, 2023.
March 28th.
Can I help you online? Sorry, December 28th on this one, the allegations that you had unauthorized contact, again, with the alleged victim, Deborah Lewison. As to that violation, how does your client want to plead?
He's guilty.
Anybody threatening you to get you to plead guilty to those violations?
No matter.
Promises being made to you in exchange for a guilty plea?
Not at all.
Actual basis.
Thank you. Mr. King, you are in the 54A District Court on charges of assault and battery and or domestic violence, correct? And as part of your conditional release, you were given a bond, is that correct?
Yes.
And part of that bond was an order from the court that you refrain from contact with Deborah Willison, is that correct?
That's correct.
Okay. And there is evidence, and do you deny that you made 30+ phone calls to her from the day?
No, I did not.
Do you deny that you were living with her and found at her house on December 28th?
I do not.
And do you deny that while in this court and passing by her in the hallway, that you told her, "I love you"?
I did.
Was there another violation that I missed one, Your Honors?
I think you covered it. The additional factual basis.
Nothing from the people.
The court is satisfied with the factual basis in each violation. I'll accept your guilty plea, find your plea to be made freely, voluntarily, and intelligently. We have a trial date on the underlying matter for June 18th. I will treat that as a final pre-trial. Ms. Lewison needs to appear in person. Let's see. How long has he been in custody?
I count 72 days, Your Honor.
As to the violation, I'll credit him time served. Any additional matters for today?
Nothing from the people.
Nothing for the country.
Counsel.
Thank you.
And you need to speak to Rose, or did you speak with?
Yes, thank you.
Okay. Ms. Donnelly.
Good morning, Your Honor.
Good morning. Which matter are you here for?
Mr. Gregory Brown Berrien is appearing by video. We have an offer to plead to a disturbing the peace that he would like to accept.
Representing Mr. Archer is Mr. Lee. Okay, and then Bernard Lewis Dean.
I represent Mr.
Yes, ma'am.
Please start your video. On the record in the matter of the people of the state of Michigan versus Bernard Lewis Dean, file number 24-00641, counsel appearance.
Assistant Prosecutor Paige Petrowski on behalf of the people.
Jacob Rowley on behalf of Mr. Lewis Dean.
Okay, Mr. Dean, today was the date that was set for a pre-trial. Was there an offer on this?
There was, Your Honor. The offer is for Mr. Lewis Dean to plead guilty to an amended count one of use of controlled substance Schedule 5 or LSD, which is MCL 333.74042C.
This time, Your Honor, we request final pre-trial and trial dates on this one.
We'll set it for trial. You're not having a final pre-trial on a controlled substance. 30th, July 30th at 8 a.m. in person at the court. Questions for the court today, Mr. Lewis Dean?
I'm sorry, can we repeat that date again one more time? It's Wendy at my job, ma'am.
Yes, your matter set for jury trial, July 30th at 8 a.m.
July 30th, 8 a.m. Yes, ma'am.
You must appear in person. Do you have any questions?
No, ma'am, I do not.
Okay, any additional matters for the record, counsel?
Nothing from the people.
Nothing from the thanks, Your Honor.
Thank you, you're all set.
Thank you. Have a
Who
good
is
day.
Same to you. Who's representing? Monty Mitchell.
That's Mr. Lee.
Okay. On the record in the matter of the people of the state of Michigan versus Gregory Brown variant, file number 23-03656. Counsel appearance.
Assistant Prosecutor Casey Crossan on behalf of the people.
And Assistant Public Defender Sarah Donnelly on behalf of the defendant Gregory Brown Berrien, who's appearing separately by video.
Heather Rose. Okay, today was the date and the time that was set for a retrial. I do see an offer here. It says the people are offering for the defendant to plead guilty to an amended count 1 of disorderly personally jostling under MCL 750.1671L, and there's a killable agreement of no upfront jail. Your client wants to accept that offer?
Yes, I believe so. Mr. Brown Berrien, is that correct?
I didn't hear it I didn't hear the last part about jail.
No upfront jail is the agreement.
All right.
You want to
Yes, I
accept that
agree.
offer?
Yes,
Okay,
ma'am.
raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes, ma'am.
Thank you. You can put your hand down. Mr. Brown Berrien, before you can accept that offer, you need to understand that there are certain rights that you have that you would have to give up. First is your right to the presumption of innocence. So you're innocent until proven guilty. You have the right to require the prosecution to prove your guilt by proving each element of the charge being brought against you beyond a reasonable doubt. You have the right to remain silent at your trial and not have silence be used against you. You have the right to confront and cross-examine any witness called to testify against you. You can waive your right to silence and testify on your own behalf. You can subpoena witnesses to testify for you at trial. And you can also produce evidence at trial that you believe show a defense to the charge being brought against you. You understand each of those rights?
Yes, ma'am.
You're willing to give all of those rights up today?
Yes.
Anybody promising you anything to get you to give those rights up and plead guilty to the amended charge?
No, ma'am.
Any threats being made to you to get you to give up your rights?
No.
Are you currently on probation or on parole?
Yes.
Which one?
Probation.
Before which court?
Wayne County.
Before what?
Wayne County.
Okay. You understand that a guilty plea could result in a violation of your probation status? You should discuss that with your attorney.
Yes.
Okay. And also a guilty plea could result in having impact on travel or immigration status that you may be seeking.
Yes.
You may also have to report this conviction to a future or current employer.
Yes.
Okay. As to amended count 1, disorderly person jostling, how do you plead?
Guilty.
Are you pleading guilty because you believe you're guilty?
Yes.
Factual basis, counsel.
Thank you, Your Honor. Mr. Brown Berrien, on December 8th of 2023, were you at your home at 441 East Edgewood Boulevard, Apartment B in the city of Lansing?
I was there, yes.
All right. At that time, you had police contact, correct?
Yes.
All right. And the Lansing Police Department, acting in their duties, attempted to detain you, correct?
Yeah, yes.
Okay, and did you attempt to resist them from handcuffing you?
Yes,
All right, and did they have to deploy a taser on you?
I don't see that there was no need, but they definitely did.
Yeah. All right, Your Honor, no further questions.
Excuse me?
I said no further questions, Mr. Brown-Berrian.
Mr. Chowski, any questions?
Nothing from the people.
Court satisfied with the factual basis, I'll accept your plea and find it to be freely, voluntarily, and intelligently made. How long is he on probation in Wayne County?
I get off in November.
Fine is $300. When are you making payment?
Soon, probably I start making the payments Monday.
How much you paying on Monday?
$50.
When you make your next payment?
The next Monday. I'm gonna clear it out like that Mondays.
Okay, so you're going to pay $50 each Monday?
Yes, ma'am.
I'll note that you'll make a payment of $50 no later than Monday and $50 each Monday until paid in full. Any additional matters for the record, counsel?
Nothing from the people.
Nothing for defense.
You're all set, sir.
All right, thank you.
I wanted to mention something. Maisha Smith set for sentencing. I believe she, excuse me, was right over on a red in Eaton County. So we need to have a brought up for that.
Nope, I do see her on my docket, but we'll bring her up, not right now, though. Okay. Let me clear these people on Zoom. Mr. Lee?
Yes, Your Honor.
Are you ready with Ms. Rose?
Yes, we are, Your Honor.
Okay, on the record in the matter, the people of the state of Michigan versus Heather Rose, file number 24-00931, counsel appearance.
Assistant Prosecutor Paige Petrowski on behalf of the people.
Assistant Public Defender John Lee on behalf of Heather Rose.
Ms. Rose, can you unmute your device? Okay, today was the date and the time that was set. Great, pre-trial, let me see, why do I have a police sheet in here? I was set for sentence and restitution here, and I don't know why the police sheet's in right there. She did already plead, and there was an amount of restitution that was provided. Are we having a hearing, or is she stipulating to that amount?
We are stipulating to that amount, Your Honor.
What is the amount of restitution?
The amount is $593.16. Yeah, Coach.
Yes. I don't know if they take a hard stance on the color.
I don't know.
I don't know. We'll find out, I guess. These are usually red, so I'm trying to figure out if they want us, if they'll take it or criminal will tell us we need to.
If I have to fill it out again, just let me know.
Okay, that's correct, Mr. Lee.
Yes, Your Honor.
Okay, and so she'll pay $593.16 to a Leslie Machala. When is she gonna make payment on that?
I get, oh, sorry, I apologize.
No, please go right ahead. Let her know.
I get paid next Wednesday, so I can make my first payment then, and then every 2 weeks until it is paid off.
Being asked to sentencing on the account 2 that she pled to, the fine is $125.
So is that going to be added on to the 590?
That is correct.
Okay.
Your $593 to the victim, and then the $125 is your fine for the court. That's a total of $718. How much are you gonna pay on your first payment?
I can make 100 on the 20th, I think on Wednesday, next Wednesday, whatever that date is, the 24th or 22nd.
Okay, next Wednesday is the 22nd. Are you gonna pay monthly or weekly? How are you gonna pay?
I would like to pay bi-weekly.
Of $100?
Can I set it for like 75? I don't want to make promises and then not be able to do it, or be responsible and not be able to do it and have more of a consequence.
I completely agree. You can do it monthly if you want. I asked you what you can do.
Okay, monthly would be great. I was just trying to get the victim money.
Correct. We when you make the payment, we apply it to the restitution first.
Okay.
Okay. Okay, so again, $100 will be payable by May 22nd, and that you'll pay $100 each month on the 22nd until paid in full.
Okay, thank you.
You're all set.
Thank you. Have a good day.
Same to you. Okay, let's see. Mr. Lee, do you need to speak to Archer or Mitchell?
We are prepared to proceed on both matters, Your Honor.
Okay, on the record in the matter of the people of the state of Michigan versus Amani Mitchell, file number 24-00718 and 719. Council appearance, please.
Assistant Prosecutor Paige Petrosky on behalf of the people.
Assistant Public Defender John Lee on behalf of Imoni Mitchell.
Imoni Mitchell has a unlicensed dog, and another unlicensed dog, and I think we reset this so that she can bring the dogs into compliance. How are we proceeding?
Ms. Mitchell was able to provide proof of licensing and vaccinating the dogs, so the people would be dismissing this case for compliance.
Okay, motion to dismiss is granted. You're all set, Ms. Mitchell.
Thank you.
You're welcome. On the record in the matter, the people of the state of Michigan versus Sergio Archer. File number 24-00979, council appearance.
Assistant Prosecutor Paige Petrosky on behalf of the people.
Assistant Public Defender John Lee on behalf of Sergio Archer.
Okay, Mr. Archer, today was the date set for pretrial for stalking. Was there an offer on this?
Yes, Your Honor. Our offer for Mr. Archer is for him to plead guilty to an amended count 1 of stalking domestic relationship with a Killebrew agreement to no upfront jail.
Mr. Lee, how do you want to proceed?
Your Honor, at this time, we would like to set the matter for a final pretrial and trial.
Did you have a plea sheet with that offer?
For Mr. Archer?
Yes.
No, I didn't have one filled out.
Okay, just repeat that for me.
Yes, the offer is for him to plead guilty to an amended count 1, stalking a domestic relationship. And I can pull up the quote for that in just a second, with a Killebrew agreement to no upfront jail. I have the NCL if you're ready for it.
Yes.
It's 750.411H2C.
On the pretrial. July 2nd, jury trial July 30th. Okay, final pretrial in person at the court, Mr. Archer, is going to be July 2nd, 8 o'clock in the morning. And then you need to appear for trial July 30th, 8 o'clock in the morning. Do you have any questions?
No, ma'am.
Any additional matters for the record, counsel?
Nothing from the people.
Nothing for the defense, Your Honor.
You're all set, Mr. Archer.
All right, thank you.
Let's see. I think I did all of those. Yes. I see Marion Smith yet? No. I see a Jacarla. Is that Jacarla McLean? Can you unmute? Who represents Mr. Kleiman?
I do, yeah.
Good morning, Judge. Good morning, and who do you have here, which that was in the court?
This young man is Marion Smith.
Oh, okay. On the record in the matter of the people of the state of Michigan versus Marion Smith, file number 24-00883. Council appearance.
Assistant Prosecutor Paige Petrowski on behalf of the people.
Jacob Riley on behalf of Mr. Smith. I have to bring to your attention, Judge, that our office is seeking conflict counsel for Mr. Smith as I represent his co-defendant, Diamond Wiggins. I've been told that I know in certain terms I cannot represent Mr. Smith.
I would agree. And she's a co-defendant in this matter. So because of that, this matter needs to be reset.
I can tell you, Your Honor, my office has just informed me about an hour ago that we may have an attorney ready to represent him at the next consultation.
Okay.
So it could be as early as next week if that is possible.
May 21st at 10:30 will be the new date. Okay, I have a bond violation here. I need to arraign you on. This is a police report. It is from April 29th, 2024. The allegations are that you violated the terms of your conditional release. Police report indicates that you were party to a traffic stop upon which the officers noted or you stated allegedly to officers that your daughter was in the back seat. Officers located the child in the back seat. There is a protective order indicating that you may only have supervised contact with that minor. The supervisor must be age 18 or older. And so that would place you in violation of your bond conditions. So you have the right to have a contested hearing. You have the right to be represented by an attorney at that hearing, okay? Okay. You're going to have an attorney appointed for your next court date, hopefully. We'll set this for a bond violation hearing at that time as well. And the court will enter a plea of not guilty on your behalf. Do you have any questions about your bond condition? We'll get you a copy of your notice to appear. Any additional matters for the record, counsel?
If I could just request a copy of the police report for the bond violation, I have received it.
Not yet, it's a whole packet from East Lansing. He was arraigned in East Lansing. That's why the file looks different. Yeah. We believe that's our criminal senate. We'll double check. Yeah. No problem. Any additional matters for you today?
No, you're not.
Okay, you're all set, sir. Okay, on the record in the matter of the people of the state of Michigan versus Carla McLean, file number 18-01189, council appearance.
Assistant Prosecutor Paige Petrosky on behalf of the people.
Jacob Riley on behalf of Ms. McLean.
Okay, Ms. McLean, today was the date set for a pre-trial. This is for a retail fraud. In 2018. Let's see, how are we proceeding?
At this time, we request final pre-trial.
Your offer.
There was, the offer was for Ms. McLean to plead guilty to an attempted retail fraud third. There is no restitution and we would have no objection to immediate sentencing as it's a retail fraud.
Okay, jury trial date. 30th.
I'm sorry, I didn't hear the lady.
Okay, can you repeat the offer?
Yes, the offer is for Ms. McLean to plead guilty to an attempted retail fraud third degree. There's no restitution on the file and the people have no objection to immediate sentencing.
Oh, no, I didn't do it. No way. No, thank you.
Okay, thank you.
Sorry,
We'll
Mr.
set it for-
Riley.
Okay, we'll set it for jury trial. You gotta appear in person, ma'am.
Yes, ma'am.
July 30th, and this is it. 18 file is probably priority, although I did set a 14 file yesterday. I don't know which one I did that for. Was that on the?
No.
Oh, okay, well then this one's gonna be priority. So you appear because you're first in line for trial, okay?
Yes, ma'am. I'm
Okay,
sorry. Mr. Riley, I thought it was a final pre-trial. Is this the same thing?
Oh, no, we're going straight to the jury trial date. Ms. McLean.
How does that work?
Well, you're gonna you have the right to a jury trial. You say you were not guilty, and you have the right to maintain your innocence. The prosecution would then have to prove that you're guilty if they believe you're guilty, and they don't want to dismiss it. They have to prove your guilt or make an attempt to prove your guilt, and they do that at a jury trial. Okay.
Well, what do they do at a final pre-trial?
I only order a final pretrial when I'm trying to assess if there's necessary witnesses. This is a matter from Target. I'm not ordering Target here for a final pretrial.
And that's what I want. That's what Mr. Riley and I discussed was a final pre-trial.
We can talk later.
I understand that might have been what Mr. Riley told you, but I decide when there's a final pretrial and when there's not.
Yes, ma'am.
So we'll see you on the 3rd. I'm sorry, the 30th.
Or the 3rd?
The 30th. You're correct.
Yes, ma'am.
We'll see you on July 30th at 8 o'clock in the morning, okay? In person.
Yes, ma'am.
We'll talk before that, okay? I'll call you.
Yes, sir.
Right.
Thank you.
And y'all gonna send this in the mail.
Your notice of when to appear will be sent to the address that we have on West Mount Hope.
Yes, ma'am. You will have a wonderful day.
You too.
Bye. I got some Lord, get me off this thing.
Oh, it's 1 minute early. I guess they'll put them on later. Okay, we did Smith, Marion Smith, that is. And then Mr. Tortora has completed his fingerprints.
Okay.
To dismiss your case without prejudice because they don't have the necessary witnesses. They are objecting to destruction of your arrest records. They do have the right to reissue the charge against you within the statutory time frame. Okay? We'll get you a copy of the dismissal and then you're all set, sir. On the record in the matter of the people of the state of Michigan versus Diamond Isis Wiggins, file number 24-00979. Sorry, 797, council appearance.
Assistant Prosecutor Paige Petrowski on behalf of the people.
Jacob Riley on behalf of Miss Wiggins.
How are you, Ms. Wiggins? I'm well, thank you. Okay, today was the date set for a pre-trial. I think our last court date negotiations were pending. How are we proceeding at this time?
Yes, there's no offer on this file.
So we would request a final pretrial and or trial date.
This child abuse first degree, I'm not, no final pre-trial. We're gonna order the kid to come forward.
Yeah.
We'll set it for jury trial.
August 6th.
August 6th, 8 AM. Obviously, if negotiations result in any offers for any matters that I don't set final pre-trials for, you just notify the court by the Friday before.
Yes, Your Honor.
Any additional matters for the record?
Nothing from people.
No, Your Honor.
We'll get you a notice to appear. Record in the matter of the people of the state of Michigan versus Maisha Renee Smith, file number 24-00133, counsel appearance.
Assistant Prosecutor Paige Grzowski, on behalf of the people.
Jacob Rowley on behalf of Ms. Smith.
How are you, Ms. Smith?
I'm fine.
Okay, you can stand up. Today was the date and the time that was set for a sentencing. I do have a pre-sentence report. Dated prepared on April 1st. Should have a copy of that, Mr. Rowley.
Yes,
To make corrections, updates, or deletions.
we have none, Your Honor.
You can make allocution.
Your Honor, I do want to inform you that Ms. Smith has, since she was last in this court, she has been sentenced on a case in Eaton County. That's retail fraud, first degree felony case. Her sentence was 365 days jail, with credit for 2 served. So she will spend the better part of the year in Eaton County jail. I think her outdate this point is in February 2025. But taking all that into account, I know the report recommends probation, and I think there are some, I think, accurate things that Ms. Smith needs to work on. She is currently working on her GED while she's incarcerated. And I think she wants to obtain that so she can have better employment prospects going forward. And having said all that, Your Honor, I would send this into discussion.
I want to make a statement. I'm reviewing the sentence report and her criminal history. Every single conviction that she has in her criminal history is retail fraud. The case that we're before the court on. So there's obviously a theme. She's going to serve a year in Eaton County, it appears. We did receive a letter. I don't know if this person sent the letter to the wrong court, but the concern was that Ms. Smith applied for a job and was offered a job and was told that she would need to provide social security and driver license to develop a working schedule. An appointment was made, and it appears that she did not follow through. The person who authored this letter, someone from My Chores Are Yours, had a concern that they believed that Ms. Smith had applied just for the purposes of providing some proof that they had a job, because there were several requests for this person or this company to provide evidence that she's employed. They found that this to be a deceptive practice and sent this asking the court to consider this prior to sentencing. Probation would not be appropriate because she's going to be in jail for a year. Hopefully, she'll have time to reflect on her actions and her past history and how she's going to move forward. Otherwise, once she's released, she'll be in the same cycle and we'll see her again at some point. It's up to you to change that. So with that being said, your fine is $300. Plus $50 state minimum costs. $75 crime victim rights fee. Total of $475. We'll refer it to collections. What's our outdate?
No, it's in February at this point.
It's February 6th, 2025.
I'll note that you're in Eaton County until that time. You will make contact with the court here upon your release to make a payment plan, okay? Do you have any questions? Any additional matters for the record, counsel?
Take from the people.
You're all set. We don't see Naisha Sumner. I don't know if that was something that was resolved, but she's not present.
So that's one of Mr. Lee's clients, and from my conversation with him, he said that she is going to be running a little late, but that also we would be asking for another trial date to give her time to provide proof that she no longer has the dogs. So he's talking to Mr. Lee.
Yeah, I was waiting for him to come back. See. Well, boy, I hope that trial goes. It's gonna be great.
Mhm.
Let me see if I can bring the jail back. Mr. Lee, while we're waiting for the jail to come back, where's Nisha Sumner?
So Nisha Sumner, I spoke with her yesterday, is at work until 11. She said she can be here by 11:15. She could not get anybody to relieve her before that.
Somebody's gonna be shut off of. Is that it? Why? It says see below, but it doesn't show me anything. Okay, Mr. Mayberry, can you hear me? Can you hear me?
Yes, ma'am.
Okay, on the record in the matter of the people of the state of Michigan versus Gaston Alfonso Mayberry, I have two files, 23-03717, 24-01109, council appearance.
Assistant Prosecutor Kate Petrosky on behalf of the people.
Assistant Public Defender John Lee on behalf of Gaston Mayberry.
Okay, let's see. Today was the date that was set for on the retail fraud, a pre-trial after a competency review and finding of competency. And then the other matter, I will have a bond violation that he would need to be arraigned on. And then there is a legal entry pre-trial. Was there an offer on this?
Yes, there was, Your Honor. The offer was for Mr. Mayberry to plead guilty as charged in either file. It's my understanding he'll be pleading guilty to count one in the file ending in 1109, which is the breaking and entering illegal entry without owner's permission, and pay restitution totaling $250. And we would dismiss the other file, which is the file ending in 3717.
I would love to arraign him on this bond violation. I have no clue what this form is. I've never seen this before in my life. It says warrantless arrest affidavit. They crossed out 56th Circuit Court and 56A District Court, handwritten 54A District Court. But it says filed at the District Court of 56A. And then I believe the violation was what's handwritten here under the other section. Violate criminal law, retail fraud, second degree at Walmart Delta. There was no police report attached, so I can't meaningfully move forward on that violation. I can only surmise that he likely picked up a retail fraud in Delta Township, Walmart, which would go before the district court 56A, but they've not sufficiently provided me information to move forward with the bond violation, so I'm going to dismiss that. And is there a plea sheet?
There is. Mr. Leach, that's time.
Maybe we set for an arraignment on June 7th for a new case for instance in the city ordinance. Yeah, we might as well do it now. We know where the file is. Let's see. Okay, Mr. Mayberry, the offer again is for you to plead guilty in file number 24-01109, which is breaking and entering illegal entry without owner's permission. Pay restitution. The amount of restitution is $250, and that the people will dismiss the retail fraud in file number 23-03717 upon entry of your guilty plea in file number 24-01109. Did you want to accept that offer?
Yes, ma'am.
Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury?
Yes.
Thank you. You can put your hand down. Okay, you have the following rights that you would need to understand, and then you have to give those rights up if you want to plead guilty. And so the first right is your right to the presumption of innocence. So you're innocent until proven guilty. Do you understand that?
Yes, ma'am.
You have the right to require the prosecution prove your guilt at trial. They have to prove each element of the charges being brought against you beyond a reasonable doubt. You have the right to remain silent at your trial and not have silence be used against you. You have the right to see, hear, or question any other witnesses that the prosecution calls to testify against you. You can waive your right to trial, waive your right to silence at trial and testify on your own behalf. You also can present evidence and testimony by way of witnesses subpoenaed to testify on your behalf and submit evidence that you believe show a defense to the charge being brought against you. Do you understand all of those rights?
Yes, I do, ma'am.
Okay, and do you want to give those rights up so that you can plead guilty to count one of breaking and entering illegal entry?
Ma'am.
Is anybody threatening you to get you to do that?
No, ma'am.
Any promises being made in exchange for you pleading guilty in this file?
Ma'am.
Are you currently on probation or on parole?
I'm currently on probation.
Before which court?
I think 54A.
Which judge?
Simmons. I think it's Richard Simmons.
Richard Simmons?
Yes, ma'am.
He's on probation for me? No. There's no Judge Richard Simmons in 54A. There's a Judge Kristen Simmons, but that's who you're before right now. And you're not on probation before me. He's not on probation at all? Are you in maybe 55th District Court with Judge Richard Hillman?
Yes, Richard Hillman. Yes, my bad.
Okay, very good, very good. I can see how you could do that. You conflate the judges' names.
Right.
Okay, so you're on probation in 55th with Judge Hillman. Do you know when you're going to get off probation?
No, I do not.
Are you aware?
He was sentenced to 12 months probation, Your Honor, on April 29th.
Okay, you understand that a guilty plea could potentially have violation status as to your probation?
Yes.
Okay, and you understand that a guilty plea could result in the conviction that you may need to report to your future employer?
Yes.
And a guilty plea could have impact on any travel status that you may seek or immigration status. So you may not be able to leave and travel out the country with a conviction of this kind. Do you understand that?
Yes, I do, ma'am.
Okay. As to count one, breaking and entering illegal entry without owner's permission, how do you plead?
Guilty.
Okay. Tell me what you did to make yourself guilty of breaking and entering illegal entry.
The door was already like cracked. I just let myself in. So.
Okay, was this at the address of 127 South Clemens Avenue?
Yes, ma'am, correct.
Is that located in the city of Lansing, Ingham County?
Yes.
Okay, that's not your address though, is it?
No, it's not.
Did you have the owner's permission to open the door and enter?
No, I did not. I was considered homeless at the time, so I was just looking for a spot to lay my head at that time of night. I didn't have nowhere to go. It was not like I was trying to be a criminal and break in the house. I just didn't have nowhere to go that night. I mean, I was considered homeless. I don't have nowhere to go. So
Okay, but you didn't have anyone's permission to enter that house, correct?
correct. Yes.
Okay, any further factual basis?
Nothing from the people.
The court is satisfied with the factual basis. I'll accept your plea and find your plea to be made freely, voluntarily, and intelligently. Is he stipulating to the 215 restitution?
Yes.
What is it for?
That is for the damage to the building that he broke into.
The damage to the what?
The building that he broke into.
Was factual basis that it was already open? Did you break something to get in?
No, I didn't. I said the door, it was already, the window was already cracked and the door was already open. I just let myself in.
How did you enter? You entered through the window or through the door?
The door, that's why I said when they cracked the door, they cracked the window. I didn't crack nothing. It was already, the door was already open. I just let myself in.
And this is for damage to the door?
This is for specifically damage to a window that was broken. There's additional details in the police report. I have no doubts of the breaking taking place by Mr. Mayberry. If
Mr. Mayberry, are you stipulating, meaning are you agreeing to pay $250 to the victim for restitution?
Yes, ma'am.
Okay, restitution will be ordered in the amount of $250 and I'll credit him. Oh, I can't because he has a PR bond. You can address his sentencing.
Oh, wait, may I approach with the restitution form?
Your Honor, Mr. Mayberry committed this crime before he was placed on period of probation by Judge Hillman. We would encourage the court to use probation as a means of not only keeping Mr. Mayberry under the court's control, but also to provide programming to assist him in rehabilitation and ability to earn and have a place of his own to avoid future crimes such as this. We would ask the court to consider running that probation concurrent to the probation out of 55th District Court.
The concern that the court has is that he's homeless. I don't think he's employed. Do you have a job?
I'm currently like I have side jobs. I don't have like a stable job. But
how much money do you make on the side job?
Like $200 a week.
A week?
Yes.
He's already on probation and then he's got 12 months, you said, probation before Judge Hillman?
That's correct.
Okay, and though probation is not free, it costs money to be on probation. He doesn't have any money. There's really no meaningful reason why I would put him on a separate probation for this court. I don't know what he's on probation for before Judge Hillman. What was the crime there? Do you know?
Retail fraud second.
Okay, so similar issues. There are allegations of crimes. Even the case that's going to be dismissed in file number 23-03717 are all crimes that are direct reflection of your financial status, which is unemployed. You're not working, you're not making money, so you don't have the ability to put a roof over your head. And so you're gonna keep, yes, sir. Hopefully Judge Hillman is ordering him to get the employment that he needs and what other programming he needs so that we won't continue to see him before the court on these types of matters. Last but certainly not least, I have people of the city of Lansing, file number 24-01402. This is a city matter, sir, that you were scheduled to be here for an arraignment on June 7th, but because you're here now, I'm going to arraign you, okay?
Okay.
There's an allegation that you received a citation on May 1st, 2024, for open alcohol in public park, possession, sell, or consume. That is a misdemeanor, maximum penalty 90 days in jail and or $500 in fine. You have the right to be represented by an attorney. You have the right to the presumption of innocence. You have the right to require the city prove your guilt by proving each element of open and talks beyond a reasonable doubt. You have the right to remain silent, not have silence be used against you. Anything that you say, anything you put in writing can be used against you. You have the right to be represented by an attorney. You're represented by the public defender's office in this particular matter, based on the indications of what you showed the court today as to your indigency status. The court believes that you would be eligible to have the public defender's office represent you at the expense of the public. Do you understand that? Okay. Did you want to request a court-appointed counsel on this file?
No.
You do not? You want to represent yourself on the open alcohol case?
Yes.
Okay, we'll enter a plea of not guilty on your behalf. We got to set this for a hearing because we need a city attorney here for that, okay?
Okay.
Let's see, pretrial is going to be the 20th. Your matter set for pretrial, May 20th at 10:30 in the morning, okay?
Just for a citation?
It's a citation for a misdemeanor. I just told you the maximum penalty on open alcohol, did I not?
Yes, you said 90 days, but I thought you was just going, you said you was just gonna sentence me right here.
Not on this, this is a new case, sir. I just arranged you on a new case. The open alcohol is not the case that you just pled to. Do you understand or do you have questions?
No, Your Honor.
Okay, so for the open alcohol, that again is a city attorney case. Today, we're here on the state of Michigan prosecution office from the Ingham County. So it's not even the same prosecutor that handles this matter. So that matter for open alcohol is going to be set for pretrial May 20th at 10:30, okay? Okay?
I said, okay, Your Honor.
Okay, I could not hear you. And so you're declining court-appointed representation. So you need to get your discovery and get your request over to the city attorney's office so they can send it to you so you can prepare yourself for that case. As to the case that you pled guilty to, again, you're only going to pay the $250 in restitution. I'm going to waive fines and costs due to your indigency status. You're all set.
Thank you.
$500 cash. I'm sorry, personal recognizance. Thank you. You're all set, sir.
Thank you. God bless you.
Thank you. Okay, that one's done. We dismissed this one. Hopefully, I signed the dismissal. And I think is that all we have for the morning. It's 11:15. Miss Sumner's not here, so she's gonna get a warrant.
She's able to appear this afternoon, Your Honor. Did you see her?
Here's my concern with Miss Sumner. June 26, 2023, failed to appear. December 21st, 2023, failed to appear. April 29th, 2024, failed to appear.
Yeah.
May 14th, 2024. To appear. She thinks that we need to work around her life for some dog licensing cases.
Was Jasmine Collins and Natasha Hodo Brown, were those both?
Bench warrants.
Okay.
Judge, I got a question.
Yes, sir.
So they don't, get this back to me. Please, right here, I don't know. Thank you, thank you. Okay. I'll show you how to. And then this afternoon. Everything you did, Jazz. I'm gonna ask Keita about it.
We have
Just get us a fake case or something.
Smith is the same case.